Hello, my name is Michael Tesoro and I've prepared this presentation on when green wash won't wash, avoiding misleading environmental claims. Bit of background about myself, I'm a competition and consumer lawyer and I work for my own practice for about 13 years now, Tesoro Legal Consulting. Prior to that I worked at the ACCC for 15 years, had a variety of roles. One of them was as the Director of Enforcement in Sydney, and in that role I ran a few environmental investigations and litigation. So I'll bring that experience to bear in this talk, hopefully. Now, the background to this particular presentation first appeared as an article in 2008 in the Law Society Journal, and after it appeared, I was asked by the young lawyers to present a seminar of the paper in 2009. And subsequently, I was asked by the Environmental Defenders Office to present the paper at their 25th National Conference in 2010, which is a great honour. And then after I presented the paper, it appeared in the EDO's journal called Impact. So it's been around a long time, this article. I have obviously updated it significantly to account for developments in the last 10 years. Outline the presentation, I'll start with the introduction, go through the relevant law, talk about why it's important to know the area of environmental and sustainability claims, and clearly a very good reason is the ACCC has made it one of its enforcement priorities for 2022. Then I'll go through some of the ACCC cases, try to distill some learnings from those cases, and then discuss two sources, the ACCC's Green Marketing and the Australian Consumer Law Guide, as well as the relevant international standard in relation to self-declared environmental claims, and then finish with some commentary. So the relevant law is fairly straightforward. The primary provision is Section 18, which is engaging in conduct which is misleading or deceptive, and that can catch a wide range of conduct. But the main reason the ACCC won't just use Section 18 is because it's not a penalty provision. There's no civil pecuniary penalty for breaching that particular section. So invariably the ACCC will join in a second cause of action, which will often be Section 29, 1A or 1G, to any claims about environmentally misleading conduct. So 29(1)(a) makes it illegal to engage in false and misleading conduct in relation to the particular standard, quality, value, grade, composition, style or model, or history or use of a product. So clearly a lot of those provisions can be used in relation to environmental claims. Clearly particular standard, quality, value would all be relevant, because I think consumers believe that products which have proper environmental credentials, higher standard, better quality and more value. But also particular history could be relevant. So if you claim that a product was made out of recyclable materials or was generated during using renewable energy, that'd be about the history of the product. So that could be used as well. Second provision is 29(1)(g), which makes it illegal to make false or misleading representations about sponsorship, approval, performance characteristics, accessories, uses or benefits. And clearly where a company claims that they have some sponsorship or approval of an environmental organisation, or they comply with the relevant Australian standard, that could be problematic. But also performance characteristics and benefits, which would both apply to most environmental claims. Consumers see the particular characteristics of a product, is that it has an environmental credential, and also most consumers would see that as beneficial. So the other section that's used often with the other two sections in environmental matters is Section 33, which is a provision that requires conduct which misleads the public as to the nature, manufacturing processes, characteristics, suitability for the purpose or quantity of any goods. So the ones that would be relevant to environmental claims is clearly the nature of the good, the manufacturing process potentially, and the characteristics of the good. So you'd often find the ACCC commencing proceedings under Section 18, 29(1)(a), 1G and 33 of the Australian Consumer Law. Now, as I said earlier, the ACCC has made environmental and sustainability claims a priority for 2022. And as Rod Sims said in his speech, greenwashing is a concern. They claim to be getting more complaints about this type of conduct, and the ACCC sees it as both a consumer protection problem and a competition problem. So consumers just are unable to determine the veracity of a product's green credentials. They don't have time to check everything out. So the regulator needs to step in to make sure that companies are properly representing their goods. But also there's a competitive element to it where companies which are doing the right thing shouldn't be losing sales to companies that are doing the wrong thing. So the ACCC believes it should intervene to make sure that the competitive dynamics of the market aren't being interfered with. Gina Cass-Gottlieb has also commented on this priority, and she has echoed Rod Sims's concerns. She stated in an article that businesses which are genuinely investing in recyclable structures, renewable energy, and expending the costs associated with that should reap the benefits. They shouldn't be losing sales to competitors who are falsely claiming that they have those same credentials. And there has been some talk as to whether the ACCC might be getting involved in the selling and claiming of sham carbon offsets. And this arises from a report by the Domestic Offsets Oversight Body, which found that up to 80% of carbon credits issued by the Clean Energy Regulator were flawed. Now, Gina Cass-Gottlieb was fairly careful in responding to inquiries about that because Clean Energy Regulator has primary jurisdiction, but I could see the ACCC and the Clean Energy Regulator may be working together to tackle this issue of sham carbon offsets. Now, the risks of getting caught for a misleading environmental claim are very high because it's obviously in the ACCC's priority list, but there are other reasons why it's a high risk area. Firstly, consumers are very keen to complain to the ACCC about things that they think might be misleading in the environmental area. A lot of people are very serious about environmental issues, but also environmental groups are very active. And I remember at the ACCC, environmental groups would always be coming to us with complaints about companies, but it wouldn't just be a complaint. It'd be a pretty well argued case for why the conduct was misleading, why the ACCC should intervene, as well as references to the relevant scientific articles that supported their view. So quite sophisticated complainants and very active in trying to get the ACCC involved. And the final risk is competitors. If a competitor is doing the right thing, has invested heavily in ensuring their products meet these environmental standards, they're going to take very kindly to a competitor cutting corners, and they're going to be straight into the ACCC to complain. So there's a high level of risk if you do the wrong thing in relation to these type of representations. Now, just going through the ACCC investigations in the past, the cases I think started largely in 2003 with a series of cases in the air conditioning industry. And these were cases that my team ran back in 2003. And what had occurred, we'd received a complaint from an environmental group saying that effectively every air conditioning company in Australia and probably in the world was engaging in very blatant misrepresentations about the gases that they put in their conditioners. So we had to work out how to approach this given how large a problem it was. So we decided to sue Sanyo mainly because it was making, in our view, the most outrageous and blatant claims. It was advertising its Eco Multi-Series air conditioners as containing environmentally friendly HFC R407C, which is a particular air conditioning gas, and they added that their products were for a new ozone era and they were keeping the world green. The problem was that R407C is considered to be a potent greenhouse gas and as such could not be considered to be environmentally friendly. Also, one of their units actually had R22, which is ozone depleting hydrochlorofluorocarbon. So to claim that it's beneficial for the ozone layer was clearly false. So we took action against Sanyo, who immediately gave up. And the first directions hearing turned out to be the settlement hearing, and the matter was resolved. And unfortunately, we didn't achieve very much general deterrence. So we decided to take a second action, this time against Daikin, who was the market leader in the market at the time, but their claims were less blatant. And after some toing and froing with Daikin, they agreed to provide an 87B undertaking to the ACCC with a wide range of obligations. Then we took a third case against Dimplex just for good measure. And by that stage, we think we were effective in achieving general deterrence to the market. Effectively, every air conditioning manufacturer in Australia stopped making claims that the gases in their air conditioning units were good for the environment. Unfortunately, a few months later, somebody sent me anonymously an email chain between two senior execs of two different air conditioning manufacturers, and they were speaking in their email about how Australia had become a no-go zone for misleading representations about environmental issues, but that the rest of the world was business as usual. So whilst we appear to have achieved general deterrence in Australia, obviously that didn't extend beyond our shores. The next series of cases involved motor vehicle companies or companies involved in that industry. First was General Motors Holden in 2008, which had made representations about the Saab motor vehicles, and it said every Saab is green with carbon emissions neutral across the entire Saab range. And the basis for this representation was that General Motors Holden was going to plant 17 native trees for every vehicle that it sold to offset the emissions. Unfortunately, that was a very short number of trees because that would only offset the emissions from one Saab for 1 year. So the ACCC was rightly concerned that that was a misleading representation, and General Motors acknowledged that that was a problem and agreed to stop making the representation, and furthermore to plant a further 12,500 trees to make up for the shortfall. I think it's fortunate for General Motors Holden that the Saab brand wasn't the top seller. The next case was the V8 supercars, who were running this Racing Green program where they were representing that they were going to plant 10,000 native trees to offset the carbon emissions from the V8 Championship Series, as well as all the associated emissions from transporting the racing teams back and forwards to the races. And the ACCC was concerned because the way this representation was made suggested to consumers that the 10,000 trees would absorb the carbon emissions from all this motor racing in a very short period of time, when in reality it was going to take decades. So that had to be clarified in their representations. Third case was the strangest I found, involved Goodyear, and they released this Eagle LS 2000 range of tyres and claimed that the range was environmentally friendly, designed for minimal environmental impact, that its production process has been changed to reduce carbon dioxide emissions. And then when the ACCC wrote to Goodyear and asked them for the substantiation, they had nothing at all. So that was a series of representations made without any substantiation, and they obviously agreed to cease making that representation. The most serious case was obviously the Volkswagen case involving diesel emissions, and this is part of a global case. And the ACCC commenced proceedings against Volkswagen, alleging that between 2011 and 2015, they'd made a range of misrepresentations, primarily arising from the operation of defeat software in their vehicles, which effectively changed the level of emissions that were recorded coming out of the vehicle during test conditions, and then shifting back to the normal on-road performance once the test finished. So this significantly understated the level of emissions being created by the vehicle. The ACCC also alleged that Volkswagen had engaged in misleading conduct by claiming that its vehicles complied with both the Australian and European standards, and finally a number of specific representations that their vehicles were environmentally friendly, clean burning, low emission, which were all untrue. Now, this case initially went to Justice Foster as an agreed settlement where Volkswagen and the ACCC agreed to pay a penalty of $75 million, but Justice Foster rejected that penalty on a range of reasons. First reason was that he believed that it was insufficient to achieve either specific or general deterrence. And then he noted the particular egregious nature of the conduct, that it was consumer fraud, that it was fraud on government departments, that had been engaged in by senior management, that the actual emissions were very dangerous to the humans and the environment. And so based on all those factors and the fact that there was no contrition meant that $75 million was simply inadequate. He pointed out that the total penalty was about $520 million at least, and therefore he decided to increase the penalty to $125 million. The Volkswagen appealed that decision to the full federal court, who endorsed or affirmed Foster's decision, and then a further appeal by Volkswagen to the High Court did not get special leave, so that penalty of $125 million stood. The next series of cases involved biodegradable and compostable claims. First case was in 2008 and involved a company called St. Evans, who was marketing this safety's natural nappy product, which it claimed were 100% biodegradable. And the matter went to court, and it was established that the products were not 100% biodegradable because they contained a number of plastic components which were not capable of being broken down through the biological activity of living organisms. So they weren't biodegradable. The next case in 2010 involved the Goody brand plastic bags, which the companies represented were both biodegradable and compostable in accordance with the Australian standard, and could legally be supplied in South Australia. But neither of those claims were correct. After the court case, it was established that the products were not biodegradable or compostable because they contained this heavy metal in quite large quantities, which exceeded the maximum concentration permissible under the Australian standard. They're also not biodegradable because they were not biodegradable, did not disintegrate or compost in accordance with the process set out in the Australian standard. The next case involved the Woolworths W Select Eco products, which was more recent in 2018, and ACCC took proceedings alleging that Woolworths had misrepresented the period of time that these products would biodegrade and compost within the right environments. And the fundamental issue here before Justice Mortimer was whether these representations were present representations or future representations. And it was pretty well established that if they were future representations, Woolworths did not have the reasonable grounds for the future representation, and therefore they would lose. But what Justice Mortimer decided was that these weren't future representations, but present representations. What she decided was because the compostable representation was capable of being true or false at the time it was made, it was not a future representation. And the second this wasn't a future representation, the ACCC was going to lose this case. And that's quite important law on the way to define future representations. And this case was appealed by the ACCC, the full federal court, and Mortimer's decision was affirmed. So this is the law in relation to future representations. The next series of cases involved flushable wipes, and the ACCC had expressed concerns about this whole issue. The fact that flushable wipes were combining to form these massive balls which would obstruct sewage works and waterways and things like that. And it commenced proceedings against both Pental Australia and Kimberly-Clark, but it also got into conversation with Aldi about the sale of flushable wipes, and Aldi decided to withdraw the products from sale voluntarily. Then the case continued against Pental and Kimberly-Clark separately, and Pental in 2018 decided to settle the case, and it admitted that it had represented that its White King flushable wipes were made from a specially designed material which disintegrated the sewage system, and that was actually not a true representation, and they agreed to pay a penalty of $700,000. Kimberly-Clark on the side decided to fight the case to the end, and then the decision was handed down by Justice Gleeson in 2019, and she concluded that the ACCC had failed to prove that the relevant flushable wipes, which was the Kleenex Cottonelle flushable wipes, were the products that were actually forming into these big balls of flushable wipes and damaging the sewage systems. So effectively, it was pretty well impossible to prove what the composition of these big balls of flushable wipes were and which companies' flushable wipes were part of the big ball. So the ACCC lost that case, which is unfortunate, but I think on the evidentiary basis, they really had no way of proving what was doing the damage specifically. There's three other cases that I identified over the last 10 years or so. The first is one that my team ran back in 2007, and this was Energy Australia was making representations about this clean air and green future non-accredited electricity products. And basically they were saying that customers who signed up to this product would get 100% green electricity at no extra cost, and that for every kilowatt hour of electricity that the consumer bought, the same amount of electricity would be generated from 100% renewable sources, and that's guaranteed. So they made these representations, and what we found was they just didn't seem to be understood by consumers at all. What we allege was consumers read the representations to understand that Energy Australia was generating renewable energy rather than buying credits of other renewable suppliers. So whilst Energy Australia didn't admit it was misleading, it conceded that it was very confusing and agreed to a range of remedies, including writing to the consumers and explaining things, providing compensation, and also contributing $100,000 to writing an educational brochure just to explain the difference between accredited and non-accredited products. The next case involved Green Power, which was operating GreenSwitch, which is a retailer of green power under the government's accredited program. So basically accepting payments from customers for the purchase of renewable energy. And what happened was Global Green, or Green Power, lost its accreditation under this scheme, but kept accepting money for consumers for renewable energy. So the ACCC discovered this was going on and forced Green Power to buy 4,000 renewable energy certificates to make up the shortfall. Fortunately, Green Power didn't comply with its undertaking, and the ACCC was forced to take it to court and obtain compliance with that undertaking. The final one involved Momentum Energy, and this is in 2018, and this saw Momentum Energy paying 5 infringement notices for offering 100% renewable energy products. And what they were doing was they were running this extensive advertising campaign on TV, print, radio, social media, website, you name it. And they were saying that they were powered by Hydro Tasmania. All our electricity is 100% renewable. But the problem was Momentum was actually buying its electricity through the national electricity market, and it just could not know where the electricity was coming from. So this was a representation which could not be true or substantiated. So the main lessons coming out of those cases, I think, is firstly, don't make any green representations unless you have the specific evidence to back up the claim. Seems pretty obvious, but a number of those companies that made claims had no evidence, for example, the Goodyear claims. Also, be careful how you use images in green marketing material. That was particularly relevant in the air conditioning cases where they used lots of images of pastures and animals and the moon, the sun, the sea, all these images which really conveyed an impression in the minds of consumers that these were environmentally friendly products. Don't overstate the environmental benefits of a green initiative. That's probably the St Evans case where it was biodegradable but not 100%, and so the claim should have been reduced and it would have been compliant. Make sure your green representations are not too confusing, and I think that's the Energy Australia example. That was just so confusing. Customers didn't know what they were buying, and I think ultimately Energy Australia realised that it had to go back to the drawing board to convey what it was seeking to convey. And then you've just got to realise that some environmental benefits are just simply too complex for a short, sharp marketing message. So if that's the case, don't even go there. Now, I mentioned a couple of resources at the beginning which might be of help. The first is the Green Marketing and Australian Consumer Law Guide put out by the ACCC. Now, one thing I'll say about this guide is it is issued in 2011, clearly is out of date. It's got references in there to the previous penalty regime, so it hasn't been updated for a while. So I'd probably suggest to the ACCC that they quickly look at this document and update it, because if they're making environmental and sustainability claims a priority for 2022, really needs to have up-to-date guidance on its website. But the guidance, general guidance it's providing is spot on, obviously. To be honest and truthful in the representations you make. Be specific as to the part of the product or process you're referring to. So if only part of the process is environmentally friendly, I guess, make sure you specify that. Make sure you use language which average members of the public can understand. So this is a confusion point. Explain the significance of the benefit. Don't make broad claims that have no context. Explain the benefits. and make sure you can substantiate all your claims. The guide also includes this checklist of things to look at. So the first thing it says there is just stay away from saying things like safe and friendly. Make sure you actually use more solid representations, not these vague type of representations. Obviously using plain language, being specific part of the product production process that the claim relates to. Make sure things will be substantiated. Obviously explaining the product is beneficial to the environment and be clear as to what that means. Don't say your product is completely environmentally benign if it is not, so that's important. And also explain the context or setting of any environmental claims. Now, the other resource that's very helpful is the International Standard on Self-Declared Environmental Claims. It spells out the specific objects of the standard. Obviously, there's a lot of consumer protection in there, being accurate, verifiable, not misleading, preventing, minimising unwarranted claims, and increasing opportunity for making more informed choices. But there's also a competition element here. So allowing market forces to stimulate environmental improvements. So if you remove questionable claims, obviously the companies that are properly innovating will get market share and they'll benefit. Also reducing marketplace confusion and facilitating international trade. So there's more to this than just protecting consumers. It's also creating a level playing field amongst competitors. And then in 5.3, they spell out some things just to stay away from entirely. They say vague, non-specific claims should be avoided, and they list them there: environmentally safe, environmentally friendly, green, nature's friend, ozone friendly, saying they're just without content, should just stay away from those particular representations. And they're saying that you can't make an unqualified environmental benefit. No matter how small it may be, all products will have some adverse impact on the environment throughout their life cycle. Then they have these resources in clause 5.7. They point out the specific requirements that every environmental claim should meet in order to satisfy the relevant standard. And it's quite a long list, but a lot of them are very straightforward. For example, be accurate, not misleading, substantiate and verify your claims, make sure it's relevant to the particular product. And then some other things that we've seen earlier, make sure you're explaining what component or what stage in the manufacturing process the claim applies to. Don't restate things in different terminology to claim multiple benefits for a single environmental change. Avoid things that can be misinterpreted. Also, consider the whole life cycle of the product, not just a phase of it. Don't claim you're being endorsed or certified by some third party or you meet some international standard. Don't claim there's an improvement that does not exist or exaggerate something that doesn't relate to your particular product. Avoid making representations that, while literally true, are likely to be misleading. Also, make sure that the environmental benefits will be realised during the life of the product. They're not speculative. Also, there's some explanatory statement that gives context to the environmental claim. Make sure they're read together. If you are going to do a comparative assessment of two different types of products, make sure that the basis of the comparison is clear and also a proper comparison. Be mindful of any recent modifications which might have changed the way the product performs. The final three is make sure you're not saying that something doesn't have some ingredients or features which have never been associated with a particular product. That's pretty blatant. Got to continually reassess the product claims you're making if products are being updated and changing through technology. And finally, make sure the claims you're making are actually relevant to the place where the environmental impact is occurring. That's a good list of things to just run through when you're making an environmental claim, making sure that all those boxes are ticked. Just some quick commentary. Obviously, companies need to be very vigilant with what they're doing in relation to environmental and sustainability claims. The ACCC is going to be very vigorous. Their record in terms of ensuring that their priorities are being met is quite well known. And there are a few focus areas where I think people have to be particularly careful. Sustainability claims have been mentioned in the priorities. Renewable energy claims are also going to be a particular focus. And there's clearly going to be some action in relation to carbon credits and offsets. And that may be a joint activity between the ACCC and the Clean Energy Regulator. As you can probably see from the early years, 2007, 2008, around that period, a lot of very blatant cases were taken by the ACCC, and they won virtually all of those cases. I think companies have learned to stay away from those more blatant types of misrepresentations. The cases which have been taken recently, for example, the Woolworths Eco case and the flushable wipes case, have clearly been more cutting edge, and the ACCC's had some bad outcomes there, but I think we can expect to see quite cutting edge cases being taken by the ACCC going forward. They're not going to be gimmies, they're going to be cases that really do push the boundaries, probably both of the law and the scientific knowledge associated with some of these claims. The final thing I want to say is that if you are in business and you do make environmental claims, you've got to make sure that you've got two things. Definitely you're going to have a compliance program in place, so strongly recommend you implement one of those as soon as possible. The other thing you need to have is a marketing checklist, a document that you go through and tick off the relevant boxes. The guides that I've included in this talk are probably a good start, but you probably want to tailor those to your specific industry and the types of advertising that you do. So that's all I had. It's going to be interesting 18 months coming up to see how the ACCC pursues this priority, the types of cases it's taking. But one thing is clear, it's going to be very active. And by the end of the 18 months, there's going to be quite a long list of cases to have a look at. So if you've got any questions about this presentation, please feel free to give me a call or drop me an email. Bye-bye.